So today, what I want to talk a little bit about is trademark searches, right? Why do we do them? Why do we have to pay for a search? And, we can just go on the trademark database and look up the mark that we want to register for trademark. Why do we need to spend this extra money? Why do we need to hire an attorney to do that? Why do we need to take these extra steps that sometimes may be a little bit more of an investment up front? And also, maybe take a little more time than just kind of this knockout search that you're going to do on the USPTO website. So let's just start with why you need a search. If you are a business owner and you are marketing your services using a name or a logo or a combination of a name and a logo or a slogan, some of our clients have all of those things and also have a musical jingle. They've been able to, really invest some time and money into what we call their sonic or audio brand looks like, sounds like. And sometimes when you are growing your business and getting to a level of success where your customers are starting to recognize you by some of what we called brand identifiers, right? Those brand identifiers, how your customers and clients are finding you in the marketplace. Well, now we are really talking about what is potentially a trademark. Now, some of the questions I get all the time is registration necessary to claim a trademark or to legally hold rights to a particular name or word or sound design that you use to let people know, hey, this is my brand of services or this is my brand of products in the industry? And that is a really important question. And I think when firms like mine start working with a client, those are the things that we're really trying to narrow down. It is not uncommon for a new trademark client to come and say, I have these 3 different logos that my graphic designer designed for me, or I have these 3 different names or concepts, and we use them interchangeably, and we'd like to reserve them. Some of the initial questions and some of the determinations that we're trying to make at the beginning is whether you have a trademark in the first place. And I know that sounds a little kind of strange, right? Because if there's a name that you want to register or a logo that you want to register and you've been using it, most of the arguments and the position of most of our new clients is that, well, I'm already using the name. I already paid a graphic designer to design this for me. I've been using it for 1 year, 5 years, 10 years, and this is the name. And this is how our audience knows us. And this is how we're going to move forward. A big part of my job, unfortunately, is letting you know that there's a possibility, letting the client know that there's a possibility that despite their use of their chosen mark, brand name, slogan, logo, jingle, or a combination of those, and sometimes these are used interchangeably. So some of the first steps that we take is just to determine, 1, whether it's a trademark in the first place, and 2, if it is and you've been using it, if it's available for registration. Now, the purpose of registration is literally simply to keep others, meaning your competitors in the same industry, from using the same or substantially the same mark in the same industry to promote their brand of goods or services. So for example, my brand, my law firm is Galvis and Company. I hold a trademark registration for Galvis and Company with the US Patent and Trademark Office in a class for legal services. But when I am working or providing legal services for Galvis and Company, I am using that mark on all of my business activities that are connected to legal services, right? So I've already sort of met some of the elements of a trademark. 1, it's a distinct mark, right? It's mine. And I'm also using it in connection with the commercial activities that I'm performing in the marketplace. Simple, plain language, I'm a lawyer providing legal services. So as long as my use matches my services, right, in my class, I am the only Galvis and company allowed to do that. Why? Not because I'm using it. And we'll get a little bit more into the weeds of that later, but just for purposes of this first office hours video on searches, the important thing to know is that I have a registration. So if another person looking to use Galvis and Company to perform legal services wants to file an application and also get a registration, meaning they want to be the only ones using Galvis and Company in the applicable class, which is legal services, immediately, if they run a search, whether it's on their own or if they hire a firm like mine to run a deep dive comprehensive search, my registration is going to show up probably at the very top of that search. Why? Because the marks are identical or substantially similar. So we'll get into those kind of distinctions, I think, in a later video. But for now, I just kind of want to give you that lay of the land to kind of make you understand why purchasing a professional trademark search from a licensed attorney from an experienced trademark law firm is an excellent idea, and why it could save you and some money and time in the long run, because it's going to answer a lot of questions about the mark that you want to reserve right up front. We're going to have a lot of answers to those questions right up front. So why make this investment? Why spend money on this comprehensive trademark search? One, it shouldn't be that expensive. And with the search, the beautiful thing is that for a small investment up front, and I say small because I'm just comparing it to what it could cost to get and find out the information that a search is going to give you after you've already filed an application, after you're already in the process window for an application. There are no refunds once you submit an application, and there are no changes to a great extent, at least what we call material changes, right? Your address can change, your attorney can change. Some things can change in the application process, but you cannot make material changes, meaning you can't change the mark that you applied for. You can't take words out, put them in, change designs. The office will not let us do that. And just as a quick side note, a lot of the fees at the USPTO went up. And most of those fees are designed to keep applicants from making very elementary mistakes, right? With your descriptions, with your preparing your application. And if you make those mistakes, if you add classes, for example, that are not relevant and you have to delete them later, you have to pay to take them away. So again, we're paying more fees because we're not doing our due diligence ahead of time. So sometimes doing your due diligence, ordering a trademark search up front can mean the difference between how much money you want to spend. It can get very expensive, or it can be reasonably expensive. Maybe it can be somewhat of an investment, but you are taking things, you're taking the bull by the horns. You're not putting the cart before the horse. You're getting a trademark search done early in the process so that you can now approach your application with more information and be able to have you and your attorney. This is something that you should definitely do with a licensed, experienced attorney. Now you can proceed with caution and also know some of what we don't know, meaning that there could be other registrations out there. And now it's not just like a question mark. Now we can actually address some of these by name and come up with a strategy for your application that can hopefully avoid delays and more fees toward the application process and hopefully to registration. This is my website. And so when you go to our website, you can go here to the menu, practice areas. And right here in brand protection and licensing, it's going to bring you to our trademarks, copyrights, and IP page. And that's actually my former intern, Vijita Patel, who's amazing. She's not working for me currently, so we are updating this website. But you're going to go right over here. And we have a trademark questionnaire form, which is very short. So now that we're here in this job form, this form is our firm's trademark questionnaire form. So what we do here is just take a few details from you about what your trademark is about, whether it's a design or words. And based on this job form, we will then go ahead and place a search order for this trademark or for the mark that you've submitted. It usually takes maybe 3 to 5 business days for our firm to order the search from the time you place the order until the time that we get the results back. And when I get the results back, I go through those. Some of these reports can be as short as a few pages, maybe 10, 20, 30 pages. A lot of them are more than 75 pages. I've even had reports that have gone as much as 300 pages. So these reports are very comprehensive, but they are going to give me a lot of information about your mark. If I see prior registrations in the search report, those are the red flags. Pink flags are going to be similar marks or registrations that are identical. That's probably a red flag, actually, and substantially similar to the mark. If there is something out there that's substantially similar or pretty identical to your mark, that is something that I'm going to flag in my analysis. I think for the most part, when clients come to me, they don't anticipate that I am going to tell them not to file an application. And in fact, this trademark report, this search report, the great thing about it is sometimes I have to not recommend application for registration because the report will let me know that there is a very high likely chance that your application will not be approved. The other side of that is even if it's something we could challenge, in other words, if you are issued an office action, which is the USPTO's challenge to our application, those can be issued for many reasons, but receiving an office action from the USPTO is going to be highly likely if your trademark search report results show a substantial or even at least one. If there's at least one registration on there and it's identical or substantially similar to the trademark that you want to apply for, I am likely not going to recommend an application, or I am going to say, if you decide to apply against my advice, you should be aware that we will receive an office action. And based on the results, that may be hard to overcome, right? And why is that important? It's not that the challenge can't be overcome, but you have to be very conscious of the investment that you are willing to make to find out in order to respond to the office actions, of which you can get up to 2. You will have to pay the attorney to prepare legal correspondence and prepare arguments to defend and basically state their case to the examiner as to why we believe that the challenge can be overcome. On the other hand of that, sometimes we do get other flags in the report. So a pink flag for me might be a mark that's using similar images, similar words, but overall, your mark and that mark sounds completely different or appears completely different, or the mark could be in an industry or in a class that's unrelated to yours, right? So this is very common for my creators who are in class 41, right? Class 41 is for education and entertainment. A lot of my content creators, a lot of our podcast creators and our, creative clients usually live in that class, right? That's the class they want. And if you are maybe launching your website and people are able to download your episodes, or you are, people are able to offload them onto their phones and listen to them later. Some of the other coveted classes for that are class 42, class 9, right? Downloadable versus non-downloadable. A lot of those classes in the technical space are highly coveted by our creative clients. So one of the things we look at is to see if, even though there are some red or pink flags, do those registrations or do those marks exist in or within the class that you are looking to get a registration in, right? If there is someone using the same name or the same mark in an irrelevant class, maybe like a food class, or, they are selling ashtrays, or they're selling, dishware, or something that is just not relevant to your industry or class of goods and services, that could potentially be something that might pose a challenge, but can potentially be overcome and might not be as expensive to pursue as trademark results that will show us prior registrations in the same class that will almost always result in a refusal. And that's an office action where the USPTO is basically saying, we're refusing your application. And if you believe that you have evidence or anything that could change our minds, essentially, let us know and we will re-review. But the beauty of this search report is that we are going to have a lot of that information up front. And once we have it, you and I can come up with a strategy, right? You and your attorney, depending on where you live and who you're working with, can come up with a strategy on how to go about filing and preparing this application so as to minimize the possibility of, one, receiving an office action, but two, also you want to make sure that even if you did, right, and it went on to registration, you want to make sure that all the classes are relevant in your application, right? Because now there are fees to remove those classes, right? The USPTO has increased fees and also added fees to make sure that they're streamlining this process as much as possible. So I think what's really great with that is that it gives the client and the attorney an opportunity to work closely together to really strategize and optimize how we are going to approach this trademark application process. These are all good reasons to order a trademark search report at the very beginning. Also, if you are working for a board, or if you are an entrepreneur or a business owner that's looking to acquire a new business, the trademark status of that business is going to be very important, right? Are those businesses brand names or brand identifiers? Are they registered with the trademark office? If they are not, how long has that business been using them? Has there been any traction in terms of demand letters, right? Is anyone else in that space using that trademark to sell their goods or to sell their services? We need to know exactly where those trademarks lie, because that is going to actually have, and I'm not an M&A attorney, but from my experience working with clients who are buying or acquiring an existing business, it can affect the sale price of that business. It can give them leverage to negotiate a lower price, right? If you have to come out of pocket to register these trademarks, to hire counsel to look into their portfolio to see where the status of the trademarks are. If you want to keep the mark and use it because that business has such a good following, and it's probably the reason that you're buying or acquiring them in the first place, you need to know that those trademarks are in good standing with the USPTO. And if not, what is it going to cost? Time and money to get those marks in that portfolio up to speed. So that's also another way that my firm works with different clients, different entities, to make sure that we are properly strategizing and coming up with a plan that meets their goal. The trademark search report is going to give us a really, really great insight into what's out there and what we need to contend with. Trademark searches, even at the level that we do them, are not fully exhaustive, but I would say maybe a very, very, very high percentage that it's going to pick up almost everything that's out there in terms of similar or identical marks. Our deep dive is also going to pick up on social media handles that are out there. So there are people that immediately buy domains, reserve social media handles, and have not done the due diligence to see if someone already has rights to that trademark. So we're going to see all of that in that report. We're also going to see business registrations at the state level. And we're going to see some common law results for trademark, right? So this applies to those of you who don't have a trademark registration, but you've been using your mark for one or several years, right? You will show up in those common law results if you, in fact, have a business presence. So, and again, there's just so much detail in these reports that really give us some insight as to how we need to go about filing this trademark application, if that will be our recommendation. Again, based on those results, the law firm or your trademark attorney may advise that unfortunately an application is not in your best interest because they don't believe that you will get a registration. You should also know that when you order a trademark search report, you always get a copy of the report. So not just our summary, any attorney that you order a report from, you should always get a copy of that report, and also know that those results, they can change at any time. Literally the day after the search report is run, those results can change. So that's why it's really important to act on them quickly. I usually require that our clients have a search report that is at least taken within the last 30 days. And that's probably being generous. I would say I wouldn't stretch it out more than 45 days because, again, literally the day after we run the search report, someone can go and file an application. So it's very important that once you decide to run that search report, try to have a plan of action for within the next 30 days. And the attorney or the attorney's office that's helping you with that should be following up with you within the week after when the search report is ordered.